Good afternoon, everybody. My name is Cassandra Peter. Welcome and thank you for joining us for our webinar today on best practices for managing misconduct and domestic inquiry. So let's be honest, every workplace has its difficult moments, right? Where HR professionals, managers, and even business leaders, if you have a small company, has to manage difficult situations when it comes to employees, right? Whether it is somebody who has a long history of absenteeism or someone who refuses repeatedly to listen to their manager's orders, right? So, how we manage or respond to these kind of situations are crucial, which is what we'll be addressing today in today's webinar. So, before we proceed, there are a few things I would like to share with you. You should be able to view a chat box, which will enable you to pose any questions. I'll try to answer some of it at the end of my presentation, or we will address as much as we can during the Q&A session at the end of the webinar. If you do not see the chat box, try exiting the full screen layout. You should be able to see it then. So just to double check, can I get a shout out from all of you in the comments in the chat box before we get started? Fantastic. All right, so let's start with our first slide for today. So let's start with the basics. What is misconduct, right? So misconduct is generally used in an employment or professional setting. If someone is arrested by the police, you don't generally hear that, oh, they've committed a misconduct. It's basically they're arrested because they committed an offense. You don't use that term misconduct for children, right? Or your kids. You don't say, hey, you did a misconduct. It's either they have been naughty, done something wrong, misbehavior. So misconduct is really very generally used for employment or professional setting. It is an unacceptable or improper behavior, especially by an employee or professional person. A misconduct is an act or conduct that is prejudicial or likely to prejudice the interests of the master, the employer in this case, or the reputation of the employer. A clearer definition of misconduct would be any conduct on the part of the employee that is inconsistent with the faithful discharge of the duties of an employee towards his employer, unless it be of a trifling nature, would constitute an act of misconduct. So, unless it be of a trifling nature simply means that it's trivial, petty, small, and would not likely prejudice the interests of the employer. So, what constitutes misconduct is also very subjective. It depends on what the organization classifies as a misconduct. So, for example, if an employee is late for 2 minutes because the elevator is slow, right? For some organizations, it wouldn't be considered as a misconduct. It happens, right? There's traffic jams, too many people trying to get the lift. 2 minutes can be considered trifling in nature, wouldn't consider a misconduct. However, for other companies who has a very strict punctuality policy, right? 2 minutes also can consider as a misconduct. So it is also very subjective. And that's why managing this kind of misconduct is also important. So why is it so important? Basically, it's because of Section 20. Now, Section 20 of the Industrial Relations Act 1967 states that where a workman feels that he has been dismissed without just cause or excuse, he can then complain in writing to the Director General of Labor to say that, hey, look here, I've been unfairly dismissed and lodge a complaint, right? Which then the industrial department will do some conciliation proceedings to try and mediate, or it will go to the industrial court. So basically, why managing misconduct is so important is because it leads to, if not done properly, unfair dismissal claims. So as long as the employee feels that he has been dismissed with just cause and excuse, he can go and make a complaint to the Director General. Therefore, it is important to bear in mind that when you manage misconduct at any point of time, that sometimes, especially in situations of dismissal, there is a possibility that an unfair dismissal claim can be done against the company. So what happens if an employee is successful? So you've done all you can, an employee files a claim and they're successful, right? So number one is the court can grant reinstatement, which is basically they'll return the employee to the former position in the company with continuity of service. If reinstatement is not possible, then the court can grant compensation, which is compensation in lieu of reinstatement, which is usually calculated at 1 month for every year of service. The court can also grant back wages up to 24 months of lost wages, or both together, and the courts can then put interest for the compensation and back wages for the company to pay. So let's take an example that an employee who is earning 10,000 was terminated due to a misconduct. And the employee has worked 10 years in the company, right? So worst case scenario, the court has granted full compensation and full back wages up to a maximum of 24 months. So the company would then be looking at a liability of 100,000 for compensation in lieu of reinstatement and 240,000 just on back wages alone. So that is a 340,000 liability for dismissing an employee. Worst case scenario, and in the event that an employee is successful. However, I do want to note here that the award by the courts also depends on merits, conduct, and equity. So it's not that every single case you're looking at the maximum figures, but when preparing and managing a misconduct, this should be at the back of your head. Like, what is the maximum liability I will be paying, or the company will be paying, if an employee is successful in an unfair dismissal claim? So, what are the legal requirements that the company has to fulfill to dismiss an employee for misconduct? So, Section 14 talks about due inquiry. It provides that after due inquiry is done, the company can impose the following punishments against the employee for misconduct, which is summary dismissal, dismissal without notice, downgrading, impose any other lesser punishment as the employer deems just and fit, like warning letters, withholding of bonus, or no increment. So that can constitute any kind of lesser punishment as the company deems fit. Even a transfer can be considered as a punishment. So what does it mean by due inquiry? So the Employment Act does not define what due inquiry means, but basically it looks at whether an investigation on the part of the employer has been done to see if the misconduct was actually committed and be satisfied that the employee had indeed committed the act of misconduct before meting out the punishments. So due inquiry basically means that I've done my investigation, I feel there are merits to proceed with disciplinary action, and then if the employee is guilty, I proceed with the punishment. So there has been a misconception when I speak to clients previously that when they hear the word due inquiry, it means domestic inquiry, that it's an interchangeable term. So due inquiry does not automatically equate to domestic inquiry. Look at it as domestic inquiry is part of the process of due inquiry. So due inquiry is that huge umbrella. Your investigations, your show cause letters, domestic inquiries are all part of the process under that big umbrella. So that is what the difference is between domestic inquiry and due inquiry. So how does an employer satisfy the requirements of due inquiry? Since there is no specific provision on the procedure for due inquiry, it merely suffices if the company adheres to the rules of natural justice, of audi alteram partem, and procedural fairness. So audi alteram partem basically means hear the other side. It's if there is a misconduct, I just want to hear what the employee has to say about it. Procedural fairness is to ensure fairness in allowing the accused employees to respond to the allegations against them. So, putting this hand in hand, you get the whole general rule or principle of natural justice. So, two things: to hear the other side, to ensure that due process is given to the employee, and you would have satisfied or you have a legal platform to dismiss the employee with just cause and excuse. Now, simply doing a basic due inquiry is insufficient to dismiss an employee for with just cause and excuse. You would also have to prove on a balance of probabilities that the misconduct actually was committed by the employee. Now, balance of probabilities simply means that it is more likely than not that the employee has conducted the misconduct. So the court has said that it is settled law that in the cases of direct dismissal, the burden is always on the employer to satisfy the court by the way of cogent and convincing evidence, though on the balance of probabilities, such misconduct have been committed by the employee, and if so, whether it deserves a dismissal. So in an unfair dismissal claim, it is not the employee that has to prove his or her innocence. It is the employer that has to prove more likely than not on the balance of probabilities that the misconduct had happened with evidence, right? So, for example, what does it mean that I say it's more likely than not? So let's say employee A was accused of sexually harassing employee B. What the company has to prove with evidence, whether it is CCTV recordings, eyewitnesses, statements, or any other form of evidence, that it is more likely than not that employee A had actually sexually harassed employee B. Once the company can say with conviction that, yeah, I have all this evidence, it is more likely than not that employee A had sexually harassed employee B, you would have proved the misconduct on the balance of probabilities. In Utusan Melayu against National Union of Journalists Malaysia, the court held that it must be remembered that in dismissing an employee, the employer need only to satisfy himself that at the time of dismissal, there were reasonable grounds for dismissal and there were reasonable grounds for believing that the offense put against the employee was committed. So when you're dismissing somebody or intend to dismiss an employee after all the misconduct or whatever issues that may have arisen, right? You have to be satisfied on reasonable grounds that a misconduct was committed. So that's your due inquiry, your principles of natural justice, and when you intend to dismiss the employee, you have to believe on reasonable grounds that dismissal was the proportionate punishment for that particular misconduct. So, what does it mean with just cause and excuse? I've been saying this phrase since the beginning. The workman believes that he has been dismissed without just cause and excuse. Section 20 makes it very clear. So, what does it mean with just cause and excuse? So, for termination of employment to be with just cause and excuse, there ought to be a proper investigation into the allegation, and the employer must be able to prove on a balance of probabilities that the employee is guilty of the act of misconduct. So, if the company conducts a due inquiry as per Section 14, which is what I stated earlier, and can prove with evidence that is more likely than not a certain act of misconduct was done, you would have legally dismissed somebody with just cause and excuse. Now, we'll go to the stages of disciplinary process. So we'll start off is that when you receive a report or you come to know of a misconduct, you'll start off with a preliminary investigation. So this is your due inquiry from the very beginning. This would come as getting evidence, getting statements, conducting interviews. You would want to see if you have enough evidence or merit to proceed with a show cause letter. So once you've done your preliminary investigation, in which you can also suspend the employee, you'll issue a show cause letter. So depending on the employee's reply, if let's say the employee responds to your show cause letter and says, hey, yes, I admit to everything, I was late or I was absent on that day, I faked my MC, whatever the charges is, if the employee admits guilty, the company can then proceed straight away with punishment. If the employee says, look, I was accused, saya difitnahkan, or you're wrong, the company is just having a crusade to get rid of me, anything that comes in a form of denial, the company should proceed to do a domestic inquiry. So then you would issue a notice of domestic inquiry, which will include the date, the time, and the place of the domestic inquiry. It will also you would also, in your notice of domestic inquiry, have to explain to the accused employee what are his rights, which is to bring any evidence that will support his case or even bring witnesses to support his case. So once the notice of domestic inquiry is issued, you'll do the domestic inquiry, where if the panel decides that the employee is guilty of the misconduct alleged against him, it'll go on to punishment. If the panel decides, no, I don't think the employee is guilty, then the case is closed and the employee returns to work as if nothing ever happened, right? So why is issuing a show cause letter important? I have gotten questions from clients in the past where they've asked, Cass, why do we need to issue a show cause letter? Due inquiry talks about investigation. Nowhere does it state that a show cause letter is needed. Why do we need to do so? So basically, when a show cause letter is issued, it provides the employer to ask the employee what is their explanation for the charges against them, which will be in the show cause letter. It goes back to your principles of natural justice, right? You're giving the employee a chance to be heard. You are putting it very specifically that, hey, these are the charges against you. Because sometimes you also have to understand your employees. If you're looking at, I'm just going to talk, I'm going to investigate, I'm going to ask you to explain verbally, the employee sometimes may not know, hey, what is actually the charges against me? You said A, but you're punishing me for B, right? Even though that B was always the misconduct that the company intended. So a show cause letter puts it very specifically that these are the charges against you. Can you please explain them? It's a written record by the company and will also give an opportunity for the employee to explain in writing, which will also be a record for the company. So when you have these written records, which is your show cause letter and your response in writing, it is easier for the company to prove in any event, whether it's an unfair dismissal claim or conciliation proceedings at the IR court or IR department, that you have given sufficient opportunity for the employee to explain. So you have adhered to the principles of natural justice, even though a show cause letter is not necessarily mandatory, but you have given the benefit of the doubt to the employee, got them to explain before proceeding with punishment. So that is the importance of the show cause letter. So even though it is not mandatory, it is highly encouraged in that sense. Now, key tips in drafting a show cause letter. You would want to avoid statements which prejudges the case. So statements such as, you're clearly absent without permission, we have decided or determined that you have falsified documents A, B, C, and D, or you were clearly guilty of failing to submit the report on time. These are all kind of statements that will prejudge the case. You would want to draft your charges in your show cause letter to state, like, for example, you were allegedly absent on 15th of April 2024. Can you please explain? So let it be very neutral. Let it be very unbiased. Allegedly, use words like allegedly, purportedly, and this will help you avoid statements which will prejudge the case. You will also want to give full and clear particulars. Ensure that all the material particulars such as date, time, and place of the alleged offense are included in the show cause letter. So you want to say things like, you were allegedly absent on 15th of April. So there's a date there. Or if it is a fighting matter, right? Employees started fighting in the warehouse. You want to say on 10th of April 2024 at 2:30 p.m., you and employee B were allegedly fighting at the warehouse in Petaling Jaya, for example. So the more details you can put in your show cause letter, the better it is. Because when you put general statements, for example, you were allegedly absent today, or you were just allegedly absent, the employee does not know how to answer it. They cannot defend or explain to that specific incident. Because if you're talking about absenteeism, what day are you talking about? Right? Or if you're talking about fights, okay, fights, but where? With who? So the more details you can put in, the better. And when you're drafting your show cause letter and the charges especially, always bear in mind the importance of the charges. Means that the way I draft the charges, how would it impact the outcome in the domestic inquiry? Or if in the event it goes to an unfair dismissal claim, how would the charges affect that outcome? So always bear in mind when you're drafting a show cause letter to think ahead, how would this impact the whole disciplinary process? If I put in a very general statement, how successful would the company be in proving that misconduct? So why are charges important? It is to specify the misconduct. Like I said, the more detailed you are, the better. They will know what are the details of the misconduct and can defend accordingly. So when you do a domestic inquiry, panel members will be confined to the charges of the case. The success of proving the charge on a balance of probabilities will depend primarily on the strength of the evidence confined to the charges that you have set, which was obtained from your preliminary investigation. Now, what happens in a situation where, let's say, you've issued a show cause letter, employee has replied, you've done further investigation, and you find out that there are additional charges that related to the same incident? What do you do then, right? Do you just sweep it under the carpet? Do you issue another show cause letter? Do you just add it in and bringing up in the domestic inquiry and letting the employee answer there and then? So the charges that you have put can be amended, whether if before the notice of domestic inquiry is given, you issue an additional show cause, or after the domestic inquiry notice is given, you want to amend the charges, it can be done. However, when you do so, provide the accused employee sufficient time to answer and defend the charge. This is the same with a show cause letter as well. So when you issue a show cause letter and you expect the employee to reply, to uphold the principles of natural justice, you would need to give sufficient time to the employee to reply to whether it's the show cause letter, amended charges, or to prepare for the domestic inquiry. So for example, I had a client who had 11 allegations, right, of fraud. And they come up to me and say, hey, Cassie, is 24 hours enough? The management really wants to get a kickstart and close this case as soon as possible. Now, the general timeline for a show cause letter is about 3 to 5 working days. If you have 11 charges of fraud, which is a complicated and complex case, 24 hours is definitely insufficient and it can be deemed to be unfair, right? So if you're going to do a 24 hours reply and if it goes to the industrial court, how would you justify whether you have given sufficient opportunity for the employee to reply, right? So these are the things that you have to bear in mind when you're managing misconduct. So there are 4 scenarios after issuing the show cause letter that can happen. One is the best case scenario for any HR personnel. I send the show cause letter, they admit guilty to everything, I can punish, close case, and move on to the next thing, right? If they deny the charges to the show cause letter, then it is recommended that you can do a domestic inquiry. If it's partially admitting, so for example, there are 5 charges in the show cause letter. 2 they admit, 3 they deny. This is the situation where it is highly encouraged that you proceed with a domestic inquiry for the balance 3 charges. Here is simply fairness. I'm upholding the principles of natural justice. I'm upholding procedural fairness. I'm giving you sufficient opportunity to explain yourself before I proceed. Either the panel decides a guilty verdict, or if let's say the panel decides a not guilty verdict for the 3, then what do you do, right? So the last scenario, no reply. So it's either the employee didn't know how to reply, forgot to reply, or simply refused to reply. What do you do? So in this situation, you can either, number 1, send a reminder saying, hey, you're supposed to reply to the show cause letter by 15th of April. We have not heard from you. Could you reply by tomorrow? If not, we'll proceed with disciplinary action. That's number 1. Number 2, if the company intends to do a punishment like warning letter or any other punishments that they deem fit and they have a very strong evidence, you can proceed with disciplinary action and do the punishment without asking or sending a reminder. Or if it's in a dismissal case, number three, where you want to be on the safe side, I would highly encourage go for a domestic inquiry. Even if the employee has not replied, send out the notice of domestic inquiry, see if the employee shows up. If the employee doesn't show up, do the domestic inquiry anyway. Ex parte means only one side, and then proceed with the verdict. And why is this so? Because then the company can show, saying, I have given ample of opportunity for the employee to defend or explain themselves. They refuse to do so. I did everything correctly. Hence, my dismissal is also justifiable. So, why domestic inquiry? Why is it so important? So, basically, the domestic inquiry, the purpose of it is a fact finding process that gives the employee a fair opportunity to defend themselves in front of a neutral panel. So it's not HR that is deciding, it is not management that is deciding. It is a neutral panel that consists of people who may not know the employee, different departments, higher in position. There is no biasness, right? Whereas if you don't do a domestic inquiry, the employee can allege that, HR always had a vendetta against me, hence they pushed for it, or management was on a crusade to get rid of me, hence the unfair dismissal. So domestic inquiry strengthens that aspect that it was decided by a neutral panel. All right. It establishes a prima facie case for the company because only in a domestic inquiry would witnesses be called, would your documents be presented. You can ask witness questions or even accuse employees questions, which will be recorded. So this ensures procedural fairness before an employer takes a disciplinary action. And when you conduct a domestic inquiry, the notes of proceedings will also help you in the unfair dismissal claim should it go to that stage. So those are the benefits of conducting a domestic inquiry, and that's why it is highly encouraged for companies to do so, especially when you're considering dismissing an employee for misconduct. So, can I suspend the accused employee during the disciplinary process? So, if it's a serious misconduct, right, you may like sexual harassment, fraud, breach of confidentiality, and if the management does not want the employee to be on the premises while investigation is being carried out, either for safety of the victim or you feel that the employee will disrupt the investigation, you can suspend the employee pending investigation, and the suspension can go on until the domestic inquiry is conducted. So it is not compulsory that every single case that you have, you're going to suspend the employee. It is in genuine cases where you feel that the employee will be disruptive or the employee would, I would say, be dramatic and create additional issues for HR, then you can consider suspending the employee pending investigation. Now, there has been a very common misconception that when you suspend an employee, it means no pay whatsoever. So clients will then, or HR professionals will then suspend the employee for 1 month and then don't pay salary. Section 14.2 of the Employment Act states that if you want to suspend an employee for the first 2 weeks, it will be on half pay. And any extension beyond the 2 weeks would be on full pay. So This is something that you also have to consider when suspending, because in the event that the employee is found not guilty, the half pay would have to be reimbursed. It is not, I suspend with no pay for as long as I like. So you suspend an employee, they don't have access to companies' database or companies' laptop or whatever it is, and it's on either half pay or full pay. All right, so this is what you have to consider before suspending an employee. Now, is it fatal not to conduct a domestic inquiry? No, it is not fatal. Case law has made it very clear. However, as I mentioned before, it is highly encouraged as it helps the company prove that the company has adhered to the principles of natural justice and procedural fairness. It shows that the company followed due process and allowed the employee to present its case in front of neutral panel, and the notes of proceedings will assist the company in the event the employee claims unfair dismissal. So, how is a domestic inquiry conducted? Now, the parties to your domestic inquiry would be your panel members, which will usually consist of about 3 people, where a chairman will be elected, the prosecutors, which will be the company, the accused employee, and the secretary, who takes down the notes of proceedings or records the whole domestic inquiry process, and the witnesses. So, a brief overview on how a domestic inquiry is conducted is that you'll start off with an introduction where the chairman will introduce the parties and ask the prosecutor to read the charges and explain the flow of the disciplinary domestic inquiry process. Now, once the prosecutor has read the charges, the chairman will then ask the accused employee, do you plead guilty or not guilty? So if the employee pleads guilty, then the chairman will record the guilty plea, case closed, everyone can go back for the day, right? If the employee pleads not guilty, then the chairman will ask the prosecutor, which is the company, to call its first witness. So the prosecutor will then ask examination in chief questions to the witness, which basically means facts to support the company's case. The witness will then be cross-examined by the accused employee, which is basically asking the witness facts to support the accused employee's case. And once that is done, the prosecutor will re-examine the witness to address any issues that may have come up during the cross-examination. At the end of that whole questioning process, the panel members will then ask the witness any questions either to clarify or any additional questions that they may have. And this sequence of questioning will be repeated for all the prosecutor's witnesses. So after the prosecutor has finished his case, we'll go to the accused employee, which will be the accused employee will call his first witness. It'll be the same thing: examination in chief, cross-examination, and re-examination. It's just that the roles are reversed. So accused employee will do the examination in chief and the re-examination, whereas the prosecutor will ask the cross-examination questions to kind of poke holes in the accused employee's defense. So the same process is then done where the panel members can ask any questions, and then this whole process is repeated for all of the accused employee's witnesses. Once that is done, the chairman can then ask for final submission, whether it is in oral or in writing, like a summary, right, of the company's case and the accused employee's case, and the secretary will prepare the notes of proceedings. Once the panel has deliberated, they will produce a report state whether the employee is guilty or not guilty, and then they will give reasons of why they think it is guilty or not guilty for each charge. And if the employee is guilty, the management can then decide on a punishment. Now, I've gone through the basic requirements, the disciplinary process, but there are two principles I would like to highlight which any HR professional should have at the back of their head when they're managing misconduct. One is what happens if an employee delays in acting on a misconduct. Employer delays in acting on a misconduct. So if an employer delays in acting on a misconduct, it will give the employee a defense of condonation. So what does condonation mean? It's basically that if I allow it to happen, if I condone it, I cannot then in the future take action for the same misconduct that I condone. So for example, an employee was absent for one day in December 2024. And the company knew about it, didn't ask for anything, left it as it is, life went on as usual. And then in March 2024, the same employee maybe irritated the management, right? And however, that conduct that he did that irritated the management was not enough to constitute a misconduct. So the company then decides to say, okay, you know what? There was that absenteeism in 2024 where we didn't do anything, we didn't minus pay, we left it as it is. Let's issue a show cause letter for that. This act of issuing that show cause for the absenteeism in December 2024, when you didn't do anything to address it at that point of time, would give the employee a defense of condonation. Basically means that once you condone the act, you have waived your right to take action. So if you don't address misconduct when it arises, and later down the line, few months down the road, you decide to take action, even by just issuing a show cause or putting punishments for that, it is condoning. You can't do so, right? So that's the first one. So in the case of counsel against Vital Vinayat, the court said that once an employer has condoned any misconduct which would have justified dismissal, he cannot, after such condonation, go back upon his election to condone and claim a right to dismiss the employee or impose other punishment in respect of the offense which he has condoned. So the first principle to always bear at the back of your head is don't condone any kind of misconduct. Even addressing it by setting a reminder means that I don't want to issue a show cause. You've done your prelim investigation and you send a written reminder saying, hey, in the future, if you have to be absent, whether it is on sick leave, emergency leave, could you please do this, and this? Or whether it's in the system, whether it's informing your superiors, even addressing it at the very time that it happened would not give the company or the employee a chance to say the company has condoned the action. However, if the absenteeism has happened and you didn't do anything about it, then it would be an act of condonation. Now, the second principle is proportionality of punishment. So not every offense or every misconduct is immediately terminatable. There are some factors that the company has to consider when you talk about punishment. Number one, the severity of the misconduct and the documentary evidence. If the misconduct is minor or your company doesn't have strong, cogent evidence, dismissal may not be a choice that a company would want to look at as punishment. The length of service of the employee and their previous disciplinary record. So let's say you have a long-serving employee and it's their first offense. This can be something that company want to consider when you're looking at punishments, right? And the last one is mitigating circumstances or explanation by the employee. Means that if, let's say, the company has done their due inquiry, the employee has explained and has admitted to the charges, you would want to proceed with the punishment, and you found that somehow the employee's explanation is kind of reasonable, even though it's a bit unacceptable, right? That could be factors to consider when you want to talk about punishment. So the key factor that you have to ask yourself for this principle is that is the punishment proportionate to the misconduct? Means if I'm late 2 minutes because the elevator was slow, does it immediately warrant a termination? Because that if it's not proportionate, that would increase the employee's chances of success in an unfair dismissal claim. Now, there are three areas I would like to talk about for managing misconduct, which is proactive. Have you taken steps or steps? Directive. Have you put something solid in place? And preventive. Do you know your employees? So, directive. Are there clear policies in place? Misconduct, no matter how you look at it, is the basis is of what is acceptable and what is not. So if employees are aware of what conduct is unacceptable, which amounts to a misconduct, and consequences of committing that misconduct, it will make managing misconduct a bit easier, right? So you have a disciplinary process in place, which outlines what is misconduct, what may be constituted as major minor misconduct, what are the consequences. Now, the benefits of this is also that when you have directives in place, awareness is given, it also gives managers a structured reference for addressing misconduct uniformly at the front line. Now, there have been situations where in one organization with a variety of departments, you get one department who is very relaxed about rules, where, for example, if an employee comes in at 10 a.m. when work starts at 9, that's fine. Then you have another HOD in a different department that says that, hello, look here, it's 9:05, and they start addressing it and flagging it up as a misconduct. So having clear policies, having clear directions on what is the uniform basis of how to deal with misconduct would be good in addressing and managing misconduct. And by doing this, you will reduce confusion and it protects the company against claims of arbitrary and or rush actions. Now, the second one is proactive. Have you taken the appropriate steps? So in managing misconduct, what you want to do is once you received a complaint of an alleged misconduct, take a step back, ask yourself a few questions, and this will help you determine how you want to address it. One is it a major or minor misconduct? So if it's a minor misconduct, do I give a written reminder? Do I have a counseling session? What can I do to address this? If it's a major misconduct, then you're looking at, okay, I need to get enough evidence. Dismissal is most likely the punishment that the management would go for. What do I need to do to ensure that when we dismiss an employee, it's with just cause and excuse? Then you can ask questions like, is it a first time offender or is it a repeated misconduct where final warning has been given? So that will also determine what is your next steps. Can it be addressed through counseling or a formal disciplinary action is warranted? Is there sufficient evidence at this point of time when I receive the complaint or I came to know about the misconduct? Or do I need to do further investigation? So these little questions that you ask yourself at the beginning can actually chart the path that you need to take to manage the misconduct. Preventive, do you know your employees? Now, every employee is different. right? You will get some who are very good persons, right? Everything is okay. Everything will be in according to policies. And you'll get some hot-headed employees who becomes very difficult to manage. So when managing a misconduct at any stage of the disciplinary process, always bear in mind the characteristics of the accused employee. Means that if I do step A, how would they react? If I do step B, would this work? And what you want to do is you would want to prevent any risk to the company with each step you take. So sometimes counseling or a one on one session as part of the investigation, you're talking about maybe your preliminary interviews, can provide an insight on the accused employee's reaction to the alleged charges. So this will determine the best way to manage the misconduct. So if you're looking at dismissal, if you already have an insight that it's going to be a very hard road, like this employee is not even going to accept the show cause letter, is not even going to accept the domestic inquiry, you can already put preventive steps in place. It means that, okay, if I need to issue the show cause letter. If he doesn't reply, what do I do? So getting to know your employees, especially at the beginning, can help in the long run. And sometimes even a gentler approach at the initial stages of the disciplinary process could provide the information needed for the company to proceed with a disciplinary action. However, I would have to caveat it doesn't work for all types of employees. You would need to know your employees well. So, these are some tips that I can help provide to manage absenteeism, which is define absenteeism clearly in policies, highlight the consequences of absenteeism. So, this will be the directive approach. Implement a clear leave application and approval process, including WhatsApp or SMS for emergencies, and make sure that this implementation is clear to everybody from subordinates, employees, managers, HODs throughout the organization. This is also part of the directive approach. Address absenteeism immediately. So, following up with necessary documentation from the employee. So, you have an employee who says, "Hey, boss, I'm on MC today." And they come back to work and no MC is given. A proactive step would be you were absent on this date. You said you have an MC. Could you please provide the MC to the company? And if they don't do so, you can then proceed with disciplinary action. Train managers to be the frontliners in addressing absenteeism, including documenting informal warnings, reminders after accepting the employee's explanation. Now, this is important. This is part of your proactive, preventive approach. If you train your managers to address absenteeism, means they know what it is, they know how to identify misconduct, and they know what to do next. This will help so much in managing misconduct because they know what to document, they know what to do, and they know the employees better. So this will also help with your preventive approach on do you know your employees? So if you're talking about absenteeism and you're talking about, habitual absenteeism, and you want to do a more formal disciplinary action, and your managers are trained, they can also assist you to identify the employee's characteristics. That will help you then decide how to manage the situation. So to sum up the whole webinar today, I have 5 golden rules. And if you follow these 5 golden rules, you're on your way to managing misconduct the best way you can, which is number 1, always conduct due inquiry before proceeding with a punishment. So when you conduct due inquiry, you're complying with Section 14 and you're safe to then met out the punishment, right? So always conduct due inquiry before proceeding with a punishment. Number 2, always allow the accused employee to explain for the alleged misconduct, preferably in writing. So this will then go back to your show cause and response. So even after investigations and you feel, hey, I just want to give a warning letter, perfectly fine. At least do the show cause letter followed by getting a response in writing from the employee. Then you would have fulfilled rule number two. Rule number three, if the company intends to terminate the employee due to misconduct, ensure that the principles of natural justice and procedural fairness are adhered to. Domestic inquiry is highly encouraged. Rule number four, documentation is important. So from the time that misconduct allegedly occurred, means when you received the complaint, any communication in between, up until punishment is given, documentation is really important. Even if you give reminders, make sure it's followed up in writing because this will help you in, let's say, it's a habitual absenteeism or habitual lateness. You would then have evidence or documentation to prove that it's not a first time offense, right? And number five, bear in mind the proportionality of the punishment. Not every offense is immediately terminatable. So if you follow these five golden rules, you're on your way to managing misconduct the best way that you can. And hopefully, you can then do the necessary to dismiss the employee if that is the intention of the company with just cause and excuse. All right, so that's the end of my presentation. We're going to go to our Q&A session. I would like to invite Victor to join me for our Q&A. And please, if you have any questions, you can put them in the comments. We will address as many as we can by the end of the Q&A.